Item number 10. No, please. It's application. See me. Item number 2. Master cases have been postponed to August. My lord, this is outsourcing regulation. And that's the only time 127, 2020. This on 8 hours. Item number 3. This problem happened in my church. Okay. Which could not be happened earlier. Okay. All right. Let's go stop. Item number 4. Manifest. Item number 5. Same one. Item number 6. Do not. Item number 7.
That may please, Lordship.
Yes, please.
There is some defect shown by the registry stamp reporter, but pages 26, 27, 29, they say not legible. But I find that it is from my copy, it is legible. But if you Lordship could ignore this defect, and it's a very short matter, but there is already a direction of this Honorable Court at page 57, your Lordship would find. And this pertains to the election of a very important association, Crop Owners Association of Keunjhar. There are around 6,000 members. They, your Lordship knows, they play very.
Why is it before a division bench? Is it a division bench matter?
It's a, that's correct, your Lordship. I think it's Justice D. Das assigned matter, your Lordship may. That the read petitions relating to election disputes of different associations. I was looking at the assignment because earlier it was listed before Justice Sahu, S.K. Sahu, Honorable Justice S.K. Sahu.
That's not
bench. Yes.
This is a bench. This is a single bench matter. This before the assigned bench tomorrow.
Assigned tomorrow.
Tomorrow. All right. Item number 8. Then another way, and I have a glance to the order dated 27/3/2023. There, your Lordship is specifically directed that the grievance of the petitioner, according to the representation, has been rejected by the RTC that the construction of the water supply facility within the school premises. Without taking a decision on that matter, instruction on this issue. I've got specific instruction that the school, which my learned friend is meaning, that school is non-functional since long. It is not at all functional. It is just like that. That school is, it is just with rival. That is school is not functioning. That I unsaid for manner, yes, there it is specifically mentioned that the school is non manner. It is able to government. So and see that I am already giving the photographs. It's not school running. School money, 2023, and appearing on advance notice, Mr. Monty, he states that as per his instructions, no school is actually functioning as of now on the plot in question. He states that he will file an affidavit to that effect. Can I submit this letter? It is specifically written. I am to say that the Saborasai UP school has been handed over by Block Education Officer Bhubaneswar by the letter of 30th September 2022. After merger of the school to the nearby school BMC in the Block 1 West. It is already merged to nearby instructions. The school is no longer functioning as the first school has merged with another school nearby in the in the neighborhood. All right. And then you see we'll file an affidavit before the next date, list from 17th August to the main bank. All right. So not any constitution or any. So I have so plans to be yes. Between standing inside the school premises that all right. What says I this is the item 9. Yes. That's mean say that to change character. Yes. Item number 9. Item 9 Item number 12. Please care for the petitioners. It's not the very spirit of giving the representation. Petitioner seeking to withdraw representation, liberty to file such representation to seek appropriate judicial costs. Yes, yes, that order.
An application for misapplication of the public
Local income, yeah. To prayer in the present petition. Given the prayer in the present petition, it will be open in the petition to approach the local in accordance with law. Except for that, liberty, the present petition is dismissed. Item number 12.
My lord, in this writ petition filed set of PIL, the petitioner challenged the previous action of the executive court for DDO, is only being confirmed to occupy number of the substance. Sampling of the Jalaso land covered hard to the interest of the public at large power. In spite of Annexure 1 series, oriented 30
Petitioner's representation, bracket Annexure 1 series, shall be examined by the Tahsildar Pulanda. And of notice to the petitioners and opposite parties 4 and 5 and giving them hearing. The reasoned order should be passed not later than August and be communicated to the parties within a week thereafter. And the court is to give the mind. Item 4 and 5. Yes, yes. Item second. Pleasure, it is also the form of behaviors. The picture challenge the irrelevance of the tenants, changing the status and nature of land, and without taking permission from the legal authority, it changes the natural flow of the water zero and constructed illegal banks. Where is the representation? Can you appreciate page 47 and 48? Then pass in your 47 and 48. 48, the additional district magistrate Puri wrote letter to OP4, and OP4 was assured to do the same. But that is a 47, 48 is about calling off some hunger strike. 47, we are in a hunger strike. And for OP4 assured us to do not obstruct the natural flow of the zero. And now the rainy season is coming. When the illegal tenants had obstructed the. It is pointed out that on 13/12/2022, the additional district magistrate Puri had asked the Tahsildar Astranga to take immediate steps for disposal of the grievance of the present petitioners and submit an action taken report. It is claimed that till date, such action taken report has not been submitted. Paragraph. The direction is issued to the Tahsildar Astranga to examine the representation already made by the petitioners and in compliance with the direction issued to him by the ADM to submit a report to the ADM for onward submission of the same to the office of the RDC bracket CEO Cuttack, not later than 17 July 2023. The court clarifies it is not expressed anywhere.
Item number 14.
It will be a copy to the petitioners.
One thing, in OP number 4, it was wrongly typed as Ostaranga Puri instead of in Tahsildar Puri instead of Tahsildar Ostarang Puri. The Ostarang maybe I also
It is noted that Tahsildar was
Ostarang. Yes.
item number
Item 14, my lord, this is a public interest litigation challenging the illegal action of some persons. There is a pond, 300 years old pond, my lord. They have illegally excavated the sand from the pond and have sold the sand. My lord, the allegations were made and the amusement report was there also that they have illegally done it.
Who has illegally done it, sir?
Pardon, my lord?
Who has done that?
Some persons from the locality.
Who are those some persons?
To whom, my lord, your lordship may kindly have a glance at page 22. There is annexure 6. Annexure 6, page 22. The persons were issued demand notice because they have illegally done it. As per the report of the revenue inspector, demand notice was issued that 4,85,000 they have to give to the government.
Who is they, sir?
Pardon, my lord?
Who is this they?
They are demand notice, but they are not included as parties.
I have not included them as party, my lord.
You have to, sir.
My representation is to collector that now they are going to put it on a new scheme and they will take the bill accordingly, my lord.
Whatever, sir. If you want an order against those persons, you have to make them parties.
My lord, if lordship will permit, I will make them party, my lord.
You don't have to permit. Your petition will be dismissed if you do not.
Sorry, my lord. I will implead them as party, my lord.
Counsel for the petitioner wants time to implead persons against whom he seeks an order as parties to the petition. Let's stop. 11 July.
My lord.
Item 15. Item number 15.
Instead of 11th, you make it 13 July. None appears dismissed.
Item number 16.
16 में reference में annex of 5 pending to open or 1 my lord. That is regarding pollution created by one poultry farm, my lord. Particularly go to NGT, sir, for this.
This is the NGT matter.
Given the nature of the prayer, it will be open to the petitioners to approach the National Green Tribunal, Calcutta Bench, Calcutta, for appropriate reliefs, granting that liberty the petition is dismissed.
For orders, item number 17.
The typing errors are ordered to be corrected. The order will now read as under. Right. Order.
So shall I return the certified copy for correction?
Not necessary, sir. It will be again. The corrected copy be uploaded again. Right.
Item number 18.
Standard 18. This appeal has already abated. Out of 7 opposite parties, 5 have already died.
Okay.
Kindly look at the age of those opposite parties. They are 76, 78. This is not the amount of a pensionary amount. They took time on 9th of January to substitute. It's a factory, a bank is, scheduled bank is fighting. Yes, they had Milan. I don't know in a pension matter.
Sir, I'm for the appellate. Kindly permit me. Thank you.
But there is absolutely no, they want to delay and they have died also in the meantime. 5 of them out of 7, they have died.
1 minute, he wants to say something. Right.
Yes, Your Lordship. Because all the retired employees, Your Lordship, we have already collected the data. We are filing this case by tomorrow, Your Lordship. We have already collected the data.
No, why is it? Cause of action alive.
Yes, Your Lordship. The only difficulty is, Your Lordship, they are taking the benefit of a judgment rendered by this honorable court, which is not applicable to their case. And moreover, kindly permit me, sir. And moreover, they have come to this honorable court as a fence sitter after the judgment of the honorable court pronounced after 3 years, Your Lordship, of the retirement. They retired in the year 2000. They appeared in the honorable court for 9 Your Lordship.
All right, counsel, the appellant states that the necessary steps are being taken within 2 days and prays therefore for a last opportunity. That is request list on.
July. I'm grateful, Your Lordship.
Item 19.
Pass on. All right, pass on.
Item number 20.
None appears dismissed.
Item 21. These three matters, 21, 22, 23, yesterday's matter, Your Lordship, disposed of on the ground of limitations. But that is, I couldn't get the order because it was not uploaded. Item 7 and 8 of yesterday's list.
In view of the order passed, will be yesterday 7 and 8. These appeals are dismissed. All right.
Writ appeal 271 and 272.
In 271 and 272. All right.
Item 24.
In those matters, my lord, I am for the
Respondent. Order.
Your Lordship, my lord, item 24. 24 is, my lord, the application was by appellant is the wife, my lord, and she filed an application for transfer of the matrimonial proceeding from Jharsuguda to Sambalpur. On the ground that she was having difficulties, she is having a minor child, a 10 years old female child. She is staying with the ailing parents, old parents, and the sister of the appellant is a physically handicapped lady, my lord. And Your Lordship,
How is an writ appeal maintainable against all this?
writ appeal is maintainable, my lord. This is our honorable High Court judgment, my lord.
All right, all right. But anyway, what's the problem?
Problem is, my lord, Your Lordship may turn to case the impugned order, my lord.
No, yes, impugned order is February 2022.
31, my lord. 31. Because the honorable single judge says, my lord, because the Jharsuguda and Sambalpur is well connected, so my application is rejected. On the ground of connectivity, my lord.
What is wrong with that?
No, the inconvenience of the lady has not been taken into account, my lord.
Jharsuguda and
Sambalpur, my lord.
I see. Even I don't. I'm new to Orissa, but even I know it's next to each other.
No,
Yes, my lord.
Your Lordship may see, my lord,
Very good road. That road I've gone on several times.
Your Lordship may see the
Excellent
judgment
road.
of this honorable court, my lord. From Bhubaneswar to Cuttack, it was transferred because the lady was inconvenienced.
All right.
Your Lordship may see,
Times
my
have
lord.
changed. It's all right. All times have changed. One of the parties is in Sambalpur, the other is in Jharsuguda, and therefore the learned single judge has rightly rejected the request for transfer. No grounds made out for interference. The appeal is dismissed.
Your Lordship may see, my lord, the grounds I have stated. Paragraph, Your Lordship may, for a moment, my lord, Your Lordship may see
Connectivity between the two cities is excellent,
page 18.
with there being a very good motorable road and the journey not even lasting 2.5 hours.
No, my lord, 45 minutes.
45
Maximum,
minutes.
not 45 minutes. Yes, yes.
All right, 45 minutes. All right. The appeal is dismissed.
Item 25. But she is having a minor child
All right.
and there is nobody to take care of the child.
All right. All right.
Item number 25.
Yes.
At 25 already notice has been issued, recusal is filed in late, it may be accepted.
The requisites already filed. We now accept it for fresh notice. Returnable. This is connected to any matter.
Yes, Malad, similar matter is fixed to 14th July.
14 July. All right.
26 also same.
All right. Same 26.
Item 27.
I am appearing for the respondent, my lord. So, your lordship. Item 26.
26 you noticed.
I
27.
am appearing.
My learned friend has appeared in 26. So
Alright.
there is no need to issue notice, Malad,
Ah.
again.
Just put his appearance in 26. You say he's entered appearance. List on
Right.
4. Right.
14th July.
Yes.
Item 27.
In item 27, Your Lordship, I beg apology. Your Lordship has already issued notice on 25th of April 2023, but inadvertently, my lordship, we have not filed the requisites. Your lordship will give me, we'll file it by today, your lordship, if your lordship permit.
All right, last opportunity to, as a last opportunity, fresh notice is issued to respondents 1 to 4 and 7 to 13 by registered speed post. Returnable on 27 July.
I'm grateful.
My lord, in sub item 2, that as per noting that opposite party number 6 and 7 not served, OPSC refused to receive the notice, and respondent
Many
number,
people not served, sir.
my lord,
The unserved respondents be again served, notice returnable. 27 July.
that is actually we have mentioned the address as per the earlier restrictions.
What was it? Right.
Corrected address of some person.
Yeah, the correct address of the petitioners of the unserved respondent is furnished to the registry within 2 weeks thereafter fresh notice. All right.
Actually, all that the interim order, your lordship.
Interim orders to cut.
Item number 28.
28, your lordship, it's come for correction.
Correct.
Somehow.
What should be status quo, is it?
Yes, your lordship, the impugn order was stayed. That was the wording.
All right.
Checked in the.
All right. The order be corrected to read as under, reproduce the order and say till the next date, the impugned order shall remain stated. All right.
Next letter listing is some total.
Mm.
June. Item number 29.
None of this. Dismissed.
Item number 30.
The order dated 24/3/23 passed by the Honorable Single Judge, wherein the Honorable Single Judge has dismissed my writ petition. Page 68, the impugned order, my lord. Operating person, my lord. Since, let's see my permitted read, my lord. Page 16 in the operating person. Since from annexure 10, the court finds that allotment to be temporary and to run a seasonal business which was for 30 days only during the year 2022, the petitioner could not have returned the scheduled land, and therefore the authority concerned, namely opposite party number 3, did not commit any error or illegality in that regard. The court does not find reason to interfere with the impugned order under annexure 10. In as much as the allotment was for a temporary duration, and hence the petitioner does not have any right to hold the railway land, and such possession has become unauthorized. My lord, the fact that, my lord, the petitioner has been allotted, temporary allotment has been made. Thereafter, in the year 2011, eviction notice has been issued. The present petitioner appellant approached before this honorable court. There was stay order till 29/22/11/2022, and this honorable court directed the present appellant to file objection. I file objection. No notice has been issued on to me to and hearing opportunity has been given to me. Impugned order has been passed. I approach this honorable court. This honorable court directed me, page 41, my lord. Relevant person, be that as it may, since the petitioner is producing some documents to support his case, in the event the petitioner makes a review application giving support of the document by annexure 3, the authority deciding the impugned order by annexure 7 may enter into reconsideration process and pass an appropriate order. Let application or review with supporting documents may be filed within a period of 2 weeks, and the decision may be shown by the competent authority within a period of 2 weeks thereafter. Thereafter, my lord, I filed review application, page 43. And again, my lord, my review application has been rejected without giving any notice and without giving any opportunity of hearing to me. That is page 47. I approach this honorable court. But they have written in the in order dated 22/2023, page 40, the relevant person, my lord. In the instant case, the railway authority has issued a temporary allotment in favor of the petitioner from 13/3/2002 to 11/2002 for selling of Holi Samagri during Holi festival. The allotment under serial number 2 of annexure 3 is clearly contained. We shall have to vacate the railway land to the original state on the expiry of the permitted period to the JUWSQQR and produce certificate to that effect. but you have failed to do so. Hence, the above said temporary allotment automatically lapses after expiring of the license period, and any other occupation is treated unauthorized occupation. As such, the occupation of the said railway land ipso facto becomes illegal and deemed as unauthorized. As per Railway Board guidelines communicated by letter number such and such dated 10/2005 and letter number such and such dated 4/10/2022 for temporary licensing of railway land to private individuals for the purpose of setting up shops, commercial offices, vending stalls, clinics, etc., not connected to the railway working, shall not be granted. My lord, the circular dated 10/2005 has been superseded. It is no more in existence. That is clear from my lord. Lordship may have a glance to page 55.
Yes.
To enable integrated development of infrastructure aligned with PM Gati Shakti framework and to attract more cargo to rail, the extent policies for leasing, licensing, and right of way of railway land have been simplified. The detailed guideline on policy for management of railway land superseding all previous policies, guidelines, instructions on the subject of lease, license, leave are encroached and annexure. My lord, when I file my review application, I have not been noticed to establish my case, and moreover, my lord, I have categorically mentioned that similarly situated person along with me have been allotted with government land. And even if, my lord, when my license has not been renewed, there is a clause, my lord, page 63. If the railway authority is put to auction, I have the right of first refusal. That is page 63, my lord.
Yes. There's nothing in this, sir. Sorry. The appeal.
My lord, with the impugned order passed by the railway authority, I have never been communicated. I have never been noticed. Without a violation of natural justice is there, gross. They simply passed the order and communicated me by way of post, my lord. Natural justice has been defeated, my lord. The very purpose of justice delivery system.
All right. The present appeal is directed against an order dated 24th March 2023 passed by the London single judge, dismissing writ petition civil 6231 of 2023, filed by the present appellant. Paragraph. The background facts are that the appellant filed an application in the year 2000 for lease of railway land and according to the appellant, he was allowed to open shop between BS/8A and BS/40A.
My lord, lordship may brought notice to page 48, my lord. The allegation that other petitioners have been, they have admitted that the other person have been allotted, my lord. Page 48. Allegation made in his application by petitioner on dated 13/23 that the railway authority has allotted plots to some shopkeepers on both sides of the petitioner, that is plot number BS/8A and BS/40A have been examined. The above said two plots are granted on license to run the business as per extant railway board guidelines, and agreement have been renewed with the above licensee time to time. But since they were similar footing, so that is violation of Article 14, my lord.
The
Page 48.
copy of the letter dated 8 March 2002, enclosed by the petitioner, by the appellant, as Annexure 3 Series 2 his own writ petition, shows that by letter dated 8 March 2002, the divisional engineer bracket headquarters Southeastern Railway made a temporary allotment of railway land in favor of the appellant, open quotation, for selling of holy samagri during the holy festival for a period from 13/3/02 to 11/4/02 bracket 30 days in the railway market / KUR area. with a total extent of 48 square feet. Full stop. Clause 2 of this letter clearly states that the appellant has to vacate the railway land and restore it to the original state on expiry of the permitted period. Paragraph. However, it appears that the petitioner did not vacate the said premises. On 7/1/2011, a notice was issued to him by the railways asking him to vacate the premises. And this he challenged by filing writ petition civil 1766 of 2011 in this court, which came to be disposed of with a single judge by an order dated 29/11/2022. Stating that in case the appellant filed an objection to the notice dated 7th January 2011, within 7 days, the authority would consider the same and pass a reasoned order within a period of 3 months. Full stop. Paragraph. Thereafter, the appellant submitted his reply to the eviction notice on 2/12/2022. So pursuant to this order dated 2022, you made the representation.
Representation that has been
Right.
passed with behind my back.
Or
Thereafter, I appealed
that
this court.
representation was disposed of by speaking order on 12 January 2023. Paragraph. It is this order that was challenged again by the appellant by filing writ petition civil 6231 of 2023. Paragraph. It is noted in the impugned order that as per the railway guidelines dated 10th February 2005, temporary licensing of railway land to private individuals for setting up shops was stopped and the ban was still continuing. Paragraph. Counsel for the appellant contended that the above order was passed behind the back of the appellant without giving a hearing, and therefore it is violative of the principles of natural justice. Full stop. Secondly, it was submitted that the guidelines dated 10th February 2005 has been superseded with the recent guidelines dated 4th October 2022. Thirdly, it is contended that certain other persons have been granted licenses. So the other persons who are similarly situated as the appellant have been granted licenses, and therefore the appellant cannot be discriminated against. Paragraph. As far as the first plea is concerned, it is seen that initially a notice dated 7th November 2011 was in fact issued to the appellant, and he managed to have a stay of the said notice passed in his favor in writ petition civil 1766 of 2011 in the initial phase. Full stop. When the matter was finally disposed of on 29/11/2022, an opportunity was granted to the appellant to file a representation within 7 days. Also, the direction was open petition The said authority shall consider the same and pass a reasoned order and speaking order as expeditiously as possible, preferably within a period of 3 months from the date of receipt of such objection, along with a certified copy of this order. Full stop, unquote. That order did not provide for the authority to give the appellant a hearing. Full stop. The appellant accepted that order and pursuant thereto made the representation. It came to be disposed of by the speaking order dated 12/1/2023. Full stop. The court therefore is unable to agree with the conflict appellant that the said order was passed in violation of the principles of natural justice. Paragraph. As far as the second issue is concerned, although the guidelines dated 10/2/2005 have been cited in the impugned order for the purposes of, as regards the ban on allotment of railway land for commercial purposes is concerned, the new guidelines do not state that they've been issued in place of the earlier guidelines. So there's no indication that the earlier guidelines superseded. So in any event, the appellant having been allotted the land in question only on a temporary basis for 30 days, way back in 2002, cannot insist that his case should be considered in terms of the new guidelines dated 4/10/2022. Consequently, this plea is also rejected. Paragraph. As regards discrimination vis-a-vis other similarly placed persons, where have you given those details, sir?
My lord,
Details of other similarly placed persons.
page 48, my lord.
One.
They are order, my lord. Page 48. The above said 2 plots are granted on license to run business.
Which 2 plots, sir?
My lord, that is plot number BS by 8A and BS by 40A. Page 48.
No, you said certain other people have been.
My lord.
My
lord,
what are their names?
Names, my lord, I don't know about plot number I have mentioned, my lord.
No. As far as the cases of discrimination are
My
concerned.
lord, they have admitted, my lord,
No.
their admission.
No details have been provided.
Their admission, my lord.
Of similarly placed.
Which is the best piece of evidence, my lord.
Full stop. In any event, it is not known in what manner they are similarly situated as the present appellant. Paragraph. Consequently, the court finds no grounds made out for interference with the impugned order of single judge. The written bill is dismissed.
I'm appearing for the railway. I'm appearing.
Item number 31.
31 will job contract 14th September.
Or 14th September.
Item 32.
Same.
All right.
Item 33.
Page 15 is the impugned order, madam. Your Lord, the second show cause notice was under challenge before the State Administrative Tribunal, and that has been set aside, and the interdepartmental proceeding has been set aside.
But you must have been asked to conduct it afresh, sir.
No, my lord. Interdepartmental proceeding has been set aside. Lordship,
What's the age of this person?
that at that point of time he was
Well, now he's 56.
my lord.
All right. The notice returnable 27 July. There shall be stay of the impugn order till then.
Item number 34.
34 my lord, rehabilitation is 30th August.
30th August. Notice of stay. Right.
Item 35.
May I please, Your Honor? Well, I have challenged the order of the Honorable Single Judge Miller in Annexure 1. This is a case of selection, appointment of selection and appointment of opposite party number 4. That was the subject matter of challenge on the ground that he doesn't have that qualification required. But the Honorable Single Judge Miller, if you also come to page 23, the ground I have taken, my lord, it at page 19. The post one, my lord, is reserved for drama acting. There are 3 disciplines: drama acting, drama direction, drama stagecraft. Having different scores, the post advertised was reader in drama acting. Therefore, the candidate was required to pass master's degree in drama acting. The petitioner passed the higher secondary vocational in drama.
Defects not removed, it says. There are 2 defects.
I'll put in one.
List on 27 July. Defects be removed.
Item 36.
And 36 my WhatsApp 14th September.
All right.
37.
37 May.
37, madam, I am appealing for the private respondents. In the meantime, madam, there has been a development because the matter carried to Supreme Court in another colleague of mine. Madam. And after the Supreme Court dismissed, madam, based on Jatin Kumar Das, because the earlier judgment was based on Jatin Kumar Das. The other person has been given appointment recently.
This case is different, my lord. He has earlier approved my lords. And my lord has allowed this honorable single has allowed his prayer. We went in a writ appeal, and that has been allowed. That writ appeal has been allowed in our favor. Thereafter, what has happened, my in this case, and these persons are appointed on outsourcing basis, my lord.
No, that's not correct.
Yes, that is correct.
In the previous writ appeal, madam, liberty was given to file review application. Review application was rejected.
No.
Then we approach this honorable court. This honorable court passed that law.
Not previously. Lords, we can find it on page 38.
Yes.
Lords, what has happened in this case? He has earlier approved the state administrative tribunal. The state administrative tribunal granted relief in his favor. That was challenged before my lords. Your lordship has observed that you file a review there. We filed a review petition before the state administrative tribunal. During pendency of that review petition, he approached my lords, and your lordship has allowed his honorable single judge has allowed his prayer to regularize his service. Your lordship, you can find it from page 35.
All right. Counsel appearing on behalf of the respondent produces a copy of the order dated 4/10/2021 passed by the Supreme Court of India in SLP Civil 13370/2021 bracket State of Orissa versus Ajit Ranjan Lenka, as well as the whereby the SLP filed by the State of Orissa against an order dated 5th February 2021 of the division bench of this court in WA number 7 of 2021 was dismissed by the Supreme Court. Full stop. Mr. Tripathi further states that pursuant to the above order, the Finance Department, Government of Orissa issued a letter dated 2nd May 2023 addressed to the Chairman, Orissa Sales Tax Tribunal, intimating him of the regularization of the services of the respondent of the said Sri Lanka. Full stop. Mr. Tripathi claims that the case of Mr. Lenka is no different from the case of the respondent in the present appeal. Paragraph. On the other hand, Mr. Kuntia, AGA, contests the above submission and points out that submits that the case of the present respondent is not on the same footing as Sri Lanka.
They are appointed through outsourcing agents, my lord.
According to Mr. Kuntia, the respondent herein was appointed through an outsourcing agency. Out.
And similar matter shall,
Notice, Mr. Tripathi accepts notice.
and similar matter shall lordship has fixed to 8th August.
No, that has got nothing to do with this case, my lord. I will demonstrate, my lord, from the record.
All right, list on. July 27. There's no contempt.
Yes, contempt.
No, I will not pursue, my lord. I will not pursue.
Mr. Tripathi states that till the next date, he will not pursue the contempt petition filed. The said statement is placed in record.
Item number
A
38.
copy of the writ appeal.
Yes, in course of the day.
None appears dismissed.
Item 39.
Please, your lordship may kindly start to see the previous order. Your lordship's direction, as per the lordship direction, the Tahsildar Hathodi has filed an affidavit, and the copy of the said affidavit was directed to serve on me one more prior to 1 week of the
We have
date.
filed the affidavit on 4th May.
The copy has not been served on me.
All right. The affidavit stated being filed by the government on 4th May. No, you see the affidavit of the Tahsildar Hathodi dated 4th May 2023 be served on counsel for the petitioner. He is permitted to respond to the said affidavit before the next date. 27 July.
Item number 40.
None appears dismissed.
Item 41.
Petitioner who appears in person. You're for whom?
Opposite party, madam.
The petitioner who appears in person is not present. Dismissed for non-prosecution.
Item 42.
42. May I proceed? The petitions are the displaced families of Bengal Dam project, my lord. Then they are residing. There is no approach road from main road to their houses, my lord. For which they have approached the authority and the authority.
What about the cement concrete road you are?
Yes, my lord. Annexure 5 and 6 are photographs that has not been executed, my lord.
1 minute, sir. Let you viewers to produce photographs. All right, Mr. Mohanty is granted one last opportunity to produce the photographs to substantiate the claim that there is a cement concrete road already constructed in the area in question. At his request list on 27 July.
Item 43.
May I please? This matter is related to unauthorized encroach of the government that we having Kisama playground, village playground LLC. So the villagers made complaint before the Tahsildar, and Tahsildar caused inquiry come to the conclusion on Annexure 3. Yes, there was a encroach of the government and directed the private opposite parties for eviction LLC. And when the said eviction has not made paid LLC, then I file a representation on Annexure 4 LLC, coupled with said order before the Tahsildar. I pray let me kindly dispose of the same LLC.
Where show as a proof.
By hand, I have been submitted the same. Here also dial fresh, I will file the same.
43 na?
Page 26, Annexure 4 LLC. 43.
No proof of submission.
Now, order LLC, we glance the relevant portion of the order. That is page 25 LLC. So far, the Tahsildar passed the order regarding unauthorized occupant and eviction LLC. And that has not been carried out by in physical LLC. So the villagers in personal meet the Tahsildar, then file and representation coupled with the said order on 20th 5 2022 under Annexure 4, page 26 LLC.
All right, it is said. But that 26, you have not, there's no proof of that representation, sir.
That's correct. Also, there has not been any postal service has not been made thereby LLC. It is not been. I may be directed to file a fresh application.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation.
Copy the order of the Annexure 3.
Implementing the order dated 21st January 2022, passed by the Executive Magistrate Nuvagam, require eviction of the encroachers on the land in question, disposed of as withdrawn with liberty spread.
Obligors.
Item 44.
44, my lord. My law and friend has served me affidavit yesterday. My law and friend has served me a copy of the affidavit yesterday. Today, my lord, I have sent it to the authorities.
What happened? We went to the assembly and now it's lapsed.
It's lapsed.
They withdrew the bill.
It is not that case.
It is,
It is a
it is
separate
relating to that execution of
It
the.
is relating
not
to
that
execution. I will come to that also.
That
is
case
also,
is posted to some other date.
but the matter remains that the RERA Act has been reduced to a dead letter in the state of Odisha. Here, the matter relates to non-execution and the
Yes, yes.
stalemate of orders before the RERA.
Yeah,
Your
law
lordship
and
may
friend
see
has
your
filed a
lordship's
copy.
last order dated 7th of February 23.
Allow me at least to take some time to from the authorities to respond
No,
to
sir,
your
that is
affidavit
me-
yesterday evening. What
My
you have
lord,
thought upon me?
Your lordship queried that how many execution cases have been, money has been recovered. So I knew they will not give any information. I have given the information and it's a big zero. The ADM has said that in no cases the money has been recovered. This they are trying
So
to
may I
hide.
kindly see my affidavit, my law and
That
friend is
your
saying
lordship
so.
may see my affidavit.
No, but you have just filed it. You say
No, I have filed it way before.
4th May.
Yes, it's a
But
nil.
served me yesterday
Not way
only.
before, sir.
Served me yesterday.
Get that.
Because I took time to get the RTI information
It's all right.
and
On
everything.
4th May 2023, the petitioners filed a supplementary affidavit giving details of the cases in which money was to be recovered and in which, according to him, no effective execution of the orders of the RERA was possible. This third party states that he needs time for instructions of the said affidavit. List on 27 July. 27 July.
Your lordship may see that under this act, neither the orders are being executed, nor sale deeds are being registered, nor association can be formed. Means it has been completely reduced to, even if your lordship's time and again direction the state government to bring that act, it was not done, it was withdrawn. So
That
I
case
think
is not posted today. You confine your argument to today's matter.
your lordship, something must be done. They cannot simply, people are being harassed, my lord.
You
Here.
keep your arguments for that date.
Yes. You argue on this case, then let us start here.
Now you argue. You start.
All right.
That after passing of the order, we will argue.
All right.
Item 45.
My lord, item 45. I have received a letter from the collector to grant some time because the inquiry is under process. The lordship has directed to cause inquiry and it will take some time. I have received a letter from the collector to pray for some time. Petitioner is not present. I'm sorry. Petitioner is not present.
All right. Mr. Monty, AGA states that the collector Cuttack requires some more time to complete the inquiry, which is already underway. The affidavit of the collector now we filed on or
The
before.
petitioner is not present today.
Yeah. On or before 14 July 2023. Bracket first line you say counsel the petitioner is not present, and then this list on 27 July.
Item number 46.
Well, the last occasion, memo was filed by the counsel for the respondent matter. And I found, my lord, the facts are correct. Because money has been paid, my lord, from out of the sources of the RNC, concerned RNC in those cases. In so far as this case is concerned, my lord, you will also leave it to the council to decide, because no decision was ever taken, no communication was ever made by the board, my lord, requiring the RNC, my lord, to pay money. But they have, in those two cases, my lord, they have paid money from out of their own fund, my lord, without there being any direction from the board.
May I please, your lordship?
Yes.
May I please, your lordship?
Let me appeal.
Yes.
So far this present appeal is concerned, my lord, we are only concerned, my lord, with the observation made by the honorable single judge. Now that the money has been given, my lord, by the respective RNC, we are only concerned, my lord, if you also look at the honorable single bench order, page 28, para 17. There it was indicated that as per the provisions contained in Act itself, nowhere the state government has been authorized under any provisions of the Orissa State Agricultural Marketing Produce Act to issue any circular which would deprive the employee of the regulator market committee of their legitimate dues. There are provisions, my lord, which government controls, my lord, the board controls the RMC. Only this much, my lord, because it has been indicated as if there is no provision in the act itself.
Milords, may I please, Your Lordship? I'll just place at the very outset, Milords, I will just place one point that the appeal is not at all maintainable. It is a time-barred petition, Milords. They have not filed an IA to that effect of for content. The judgment that they are challenging is filed on 26/3/2019. They have filed this writ appeal on 27 of February 2022. After almost a year, they have not also filed
stamp reporting. How did the stamp reporting come? What?
Milords, there is a judgment that an appeal has to be admitted or to be taken on merits only after the condonation of delay has been filed or has been considered.
1 minute. Let's just try and ascertain how they numbered it without delay being.
Maybe.
You never certified copy. You say it appears that the certified copy, the impugned order was never filed, and the stamp reporting therefore did not account for the obvious delay in filing the writ appeal. Full stop.
But we have filed
The writ appeal was filed on 20th February 2020, whereas the impugned order of the learned single judge was dated 26th March 2019. Paragraph. Counsel to the appellant. What do you want to do, sir?
But because, my lord, I am not agreed by any now, my lord, because they have
Faced with this difficulty, counsel to the appellant states that he will withdraw the present appeal.
Well, only, my lord, your lordships observe that because the
no, Milords, it should be outrightly dismissed.
Dismiss it on delay.
Milords, it should be outrightly dismissed.
Not now.
But we have filed, my lord, based on the order received from the registry.
No. You're not given the impugned order at all. So no application for delay, nothing. The defect pointed out way back on 6th March 2020 by the registry was not cured at all. Paragraph, the court does not propose to grant any further indulgence to the appellant of this court. The appeal is accordingly dismissed.
I'm grateful, Milords.
But there are two appeals.
The second application suffers the same consequences, Milords.
Right.
Item 48.
May it please, my lords.
8 minutes. I'm appealing for the sole respondent.
So you're appealing for the respondent?
Sole respondent, I'm appealing for sole.
Mr. Rathi. Because I've served a copy. My lords, this is a challenge to the order of the learned single judge dated 24/1/2020 on the grounds that arrears of pay along with interest has been granted all throughout, although there was no prayer for the same. Lords, may kindly come to page 20 of the brief, middle of the page. This is judgment of the learned single judge. Yes. It is in the circumstances. Yes. My lord, I am placing that. In the circumstances, this court finds for the petitioner deemed to have been appointed against the post of Deputy Manager Technical / Assistant General Manager Quality Control since 31/1/2000, non-consideration of the case of the petitioner along with the case of the other persons as appearing at Annexure 4 on the premises that he did not have the experience of required number of years becomes illegal. This being the only reason for non-consideration of the case of the petitioner, this court interfering in the order at Annexure 4 directs the Food Corporation of India for giving promotion to the petitioner for the post of DGM.
Yeah,
why should you need arrears of pay, sir? From the date you actually get promotion, you should get.
Notionally, it has to be fixed notionally and pay has to be fixed. Yes.
All right. Having heard learned counsel with the parties, the court clarifies that as far as the period for which the petitioner was not working in the promotional posts, he would not be entitled to arrears or any interest on such arrears. The promotion will be given notionally from the date that the appellant's respondents juniors were so granted on notional basis, and that date will count for the purposes of seniority and all other benefits, including retirement.
Pay must be accordingly fixed, my lord.
Sorry?
Pay is to be fixed accordingly.
The pay of the appellant, respondent will be fixed accordingly.
Obliged.
So, with this clarification, the appeal is disposed of.
Obliged.
Item number 49.
Lord, same orders to be passed because your lordship has referred the matter. 27 July in the leading case in that Mamata Kumar. Vigilance.
All right. Same order.
Only status quo to be
Till such time status quo shall be maintained.
because they are still continuing.
Yeah, all right. So that petition will go to the judge. Right.
Item number 50.
In item 50, your lordship already issued notice. In this case, my lord, I am appearing for opposition today. I filed and your lordship can fix it to tomorrow. But similar matters are coming that promotion during penance of vigilance.
List tomorrow. Interborder to cut.
Tomorrow. Today filing the power.
All right. It's coming up tomorrow anyway.
My lords.
Pass over.
Well, one pass over. Pass through matter item number 19.
The lordship may and to the order dated 9/1/2023, where I was directed to take fresh notice. I've already taken the notice whether it has been served or not.
But I have instructions to appear on the. But I have instructions to appear on behalf of the.
All right. Counsel enters appearance on behalf of the respondent. List on 17 July. Defects be cured in the meter. Over. Mrs.
Obliged. First admission item number 1. CRLMC 1883 of 2018.
My lord, item number 1. Last time I praised that I was outing instruction from the petitioner, and the state of the trial is that trial has not yet started and completed, my lord.
Correct.
Now, my lord, this is a case when there is an accidental death, and in the Delang railway station near Khodar railway station, my lords, on 16 April 2015. Now, when the family of the victim came to know of the incident, then they demanded that the accidental death was caused due to the inaction of the railway authorities, and demanded some amount of money and as well as job in that respect. But they didn't recover also the dead body. And the next day morning, my lord, on 17 April 2015, at about 7 a.m., there are around 100 to 200 people, as per the allegation of the my lord.
Charge sheet has been filed.
My lord, this is the impugn order is order of cognizance. That is of 2017. My lord, several accused persons, 40 accused persons are there. It has been split up. Some are absconding against whom NBW has been issued. Against them, summons have been issued. And they have done damage to public property. That's why that PP Act also has been invoked, and Railways Act have been invoked. So let them appear and
correct.
My lord, in the present case, my lord, the petitioner was not at all present in the situation. Also, he is not related to the victim.
All that you prove in the trial, sir.
Yes.
Permitting the petitioner to raise all please the appropriate stage, the petition.
My lord, since the matter is pending since long, after the charge sheet already been filed, so in that view of the matter, I think the petitioner also requests that his name may be deleted because he doesn't belong to the relation of that victim. Otherwise, also doesn't belong to the mob which vandalized the railway station. This is my humble submission.
Item number 2.
None of this dismissed.
Item number 4.
Same on.
Item number 5.
Same on.
Item 6.
Same on.
Item number 7.
Same on.
Item number 8.
Same on.
Item number 9.
Same on.
Item number 10.
Same on.
Item number 11.
Same on.
Item number 12.
Same.
Item 13.
Same on.
Item number 14.
Item 14, I will permitted to raise all the questions before the Lord.
Permitting.
Item number 15.
Same on. None of this dismissed.
16.
Same.
Item 17.
And in this application, my lord, the petition challenges, my lord, the order dated 1/3/2021, my lord, wherein Lawrence, my lord, CJM directed to transfer the case and record to OPID court, my lord. This is a case of 2013, my lord. Most of the witnesses have already been examined, my lord. Again, my lord, I will, my lord, after
Permitting the petitioner to request the trial court to expedite proceedings. The petition, the impugned order is not interfered with. The petition is dismissed. All right.
Item 18.
None of this dismissed.
Item number 19.
Same order.
Item number 20.
Same order.
May it please, your lordship. Item number 20, my lord.
Yes.
The petitioner challenged the cognizance order, your lordship.
Right.
Your lordship may kindly direct the petitioner raise all this matter.
Yeah, permitting the petitioner to raise all please. All right.
Liberty may be kindly granted, your lordship.
Correct.
Item number 21.
21, my lord, kindly taken up after vacation.
No. What is?
Lord, challenging the order of taking cognizance. My lord, the petitioner say in-laws. Lord, say I am taking time for after vacation.
No.
Lord, after vacation.
Sorry, sir.
Because of the file is misplaced.
That's even better. Counsel, the petitioner states the file has been misplaced.
My lord, your lordship may kindly all the ingredient move before the charge.
All right. Permitting the petitioner raise all pleas at the appropriate stage.
All before the charge, my lord.
All right.
22.
None of this dismissed.
Item number 23.
We have to put the prayer clause. None of this dismissed.
Yeah, please. Item 23. This is a case where my 227 petition for discharge was rejected by the district judge with insufficient ground, which is under impu order is on annexure 1, page 9. The fact is that the petitioner, while sleeping in his house and 2 days after was supposed to join in a government job, was picked up by the police and arrested and forwarded on the ground that he was transporting cough syrups. And NDPS case under section 21B was imposed against him. The discharge petition was rejected without any ground, and further development is that the PW1 in the court below has stated in his deposition that they have seized the cough syrups from the bus, not from this person. This person was sleeping in his house and he was picked up by the police.
It's alibi. You're pleading alibi.
No, not alibi. He was sleeping.
You're not pleading alibi. You're pleading alibi. You've not heard of that expression, sir?
Alibi.
You have the smartphone.
Yes.
You have a smartphone.
Yes.
Just in the Google, just put alibi. Have you heard of this expression, sir, alibi? You're not aware of this legal expression, alibi?
Sorry, my lord. I don't.
Arre, very strange. All right.
Page 12, your
You
lordship.
handle criminal matters, sir.
Yes.
You've never heard of this expression alibi?
Never gone through.
Very strange. Very strange. All right.
It is.
You have heard, no, sir?
Yes, yes.
All right. Sometimes I wonder whether I have to go back to law college.
No, my lord.
It's all right. It's all right. We're all learning. We're all only learning.
Lordship, I kindly have. I am just reading out what section 21 says. Whoever in contravention of provision of this act or any rule or order made or condition of license granted thereunder manufactures, possesses, sells, purchase, transports, import, intercept, exports, intercept, or uses any manufactured drugs or any preparation containing any manufactured drug shall be punishable. So here, what section, what ground is applicable to this petitioner? None of this. So how the petitioner is accused? And why his discharge petition was rejected?
Anything else, sir?
One small prayer may, Lordship may call the LCR and fix it to after vacation so that the deposition of the PW1 will clarify everything.
All right. The challenge in the present petition is to an order dated 6th December 2021, passed by the learned District and Sessions Judge, Nuapada, Special Judge Nuapada, rejecting the petitioners in SA case number 8 of 2019, rejecting the petition of the present petitioner under section 227 CRPC, seeking discharge in the aforementioned case, in which he is now facing trial under section 21 bracket small b of the NDPS Act, read with section 27 bracket small b bracket small 2 of the Drugs and Cosmetics Act 1940. Paragraph. The case of the prosecution is that that 160 ESKUF cough syrup bottles packed in cartons were recovered and seized from the possession of the present petitioner. And on being asked, he could not produce any satisfactory document justifying his illegal possession. Full stop. The trial court has come to the conclusion that there is a strong prima facie case against the petitioner, and the materials gathered by the prosecution are sufficient to put him on trial. Paragraph. Counsel for the petitioner states that the case of the petitioner was that he was sleeping in his house and was not even present when the alleged seizure took place. Stop. Although it was put to the counsel for the petitioner that he's in effect pleading single quotes alibi, counsel of the petitioner pleaded ignorance of that expression and stated that he had never heard of it before. Paragraph. Be that as it may, in a criminal trial, if the accused is pleading single quotes alibi, the burden of proof would be on the petitioner to discharge, and that obviously will be tested at the stage of trial. Full stop. The court is unable to find any error having been committed by the trial court in framing charge against the petitioner and in declining to discharge him at this stage. There is no merit to the present petition. It is dismissed as such.
Item number 24. Item 24.
None appears dismissed.
Item number 25.
Your Lordship, item number 22. Your Lordship, my learned senior counsel, Mr. Das, is not well.
22 is over, sir. Right.
Item 25.
None appears dismissed.
Item 26.
None appears dismissed.
Item number 27.
You have to put the praise on.
No, item 27, my lord, petitioner challenge the order of warrant issued against him, my lord, on 10/1/2019, my lord, page 16, my lord, by the Warrant JMFC Bottom, my lord. Warrant has been issued, my lord, against the petitioner.
What's the offense, sir?
498 and other offenses, my lord, matrimonial dispute, my lord, arising out of the complaint petition, my lord.
All right. Not inclined, sir. What do you wish to do? All right. See the prayer, the present petition, reproduce a prayer. Having heard learned comes from the petitioner and considering the nature of the offense, the court is not inclined to grant the relief as prayed for. The petition is dismissed.
Item number 28.
The correction we carried out as pointed out.
Item 29.
May I please the lordship? The lordship, the petition is infructuous and permitted to be withdrawn.
Or dismissed as withdrawn.
Obliged.
Item 30.
Lordship, I mean VC, Lordship prayed for filing a fresh requisite, Lordship.
No. What's the matter about, sir? What is the matter about?
I'm the associate of K.N. Patnaik. I instruction of my senior.
Or you just say permitting the petitioner raise all claims at the appropriate stage. The petition is dismissed.
Item 31.
None appears dismissed.
32.
Same on.
Item 33.
Item 33 and 34, my lord, liberty be given to raise the points on court below.
All right. Permitting the petitioner to raise all claims.
Item number 35.
35, my lord, in this case, charge has already been filed in the court below, my lord, from 27/12/16, but the trial has not been commenced, so my lord, let it be targeted to complete.
All that you can target. Permitting the petitioner to raise all claims.
Item 36.
None appears dismissed.
Item number 37.
Same on.
Item 38.
Same on.
39.
Same on.
Item number 40.
May I please, your lordships? Well, that the instance of opposite party number 2, your lordships, one complaint case is, my lord, filed and which is subsequently registered. The petitioner has love affairs with OP number 2. Therefore, there was disturbances. And subsequently, my lord, the dispute was decided by the Mahila Commission, and it was decided they both will get married. They have got married under Annexure 3, page 21.
You want to examine it, sir? Counsel of the state states that he needs time to verify the genuineness of Annexure 3 and also produce a report of the IIC concerned, who will speak to the opposite party number 2 and ascertain the present position. This before the roster bench on 19 July.
Item 41.
None appears dismissed.
42.
Same order.
Item 43.
Same order.
44.
Same order.
45.
My lord, on behalf of Mr. Koshiguru, the petitioner is died, my lord.
Or dismissed as having abated, since the petitioner stated who died.
Item 46.
May I please? This case arises out of the maintenance and DB Act. In the meantime, petitioner and opposite party are separated. The divorce was allowed and permanent alimony was granted.
So it's infructuous.
My lord.
Dismissed as infructuous. All right.
Item 47.
None appears dismissed.
Item number 48.
Same order.
49.
Item 49, I pray liberty may be granted to raise all.
Or permitting the petitioner to raise all.
Obliged.
Item number 50.
None appears dismissed.
51.
Same order.
Item 52.
Same order.
53,
Same order.
item 54,
Same order.
item 55,
Same order.
56,
Same order.
item number 57,
Same order.
item number 58,
Same order.
59,
Same order.
item number 60,
Same order.
61,
Same order.
62,
Same order.
63,
Same order.
item 64,
64, my liberty may be granted to
Or
raise all.
raise all, please. All right.
Go best.
item number 65,
None appears on both matters.
item 66,
66, my lord, based on the accusation of 376(2), the under section 53A, the direction was to test the paternity. In the meantime, the charge has been quashed. 376(2) and it's been quashed.
So this is infructuous now.
But this has to be set aside. Infructuous cannot, because the order is on.
Yeah, by a separate order dated 23rd March 2023 in criminal MC number 1493 of 2021. The charge against the petitioner for the offence under section 376.
Last
squashed.
one.
Yeah, stands squashed. In that view, the matter, the present petition is disposed of as infructuous.
And infructuous is still that order will be other offences for which I will be tried. So the order will remain. So if
All
lordship,
right, you say as the present petition is disposed of, permitting the petitioner to raise all appropriate pleas regarding the other offences.
now other offences I am not troubling. My lord, this order has to be set aside because this order cannot sustain. 53A is for only rape, and now rape allegation has gone. It is to be set aside, man. This impugned order is under section 53, passed under section noting 53A.
Where is the 33/2021 order?
No, that is at page. That is at page 23, my lord. In the second paragraph, your lordship, section 53A of the 53A of CRPC.
All right, in that way, the matter, the impugned order dated 30th March 2021 does not survive and is accordingly set aside. The petition is disposed.
Obliged.
item number 67,
May it please your lordship. Your lordship, the petitioners challenge the criminal proceeding taken the plea of alibi, and this court has been pleased to issue notice to the opposite parties, your lordship. But there is no stay on further proceeding. For that reason, the court already proceeded with the matter, and the petitioner are already acquitted with the charge.
All right. Due to
Now the petitioner has become infructuous.
rendered infructuous, it is disposed.
Grateful.
item 68,
Item 68, my lords, I may be permitted to raise all the grounds for time of payment.
All right, permitting the petitioner to resolve this.
69,
Manifest.
item number 70,
May please your lordship, my lord. Well, I have a limited prayer, my lord. By the Annex 2, I was granted permission to cross-examine the witnesses 1 to 5, subject to payment of 1,000, my lord. But I could not submit that.
That is 2013 matters. No question.
Subject to any condition, I will pay, my
No,
lord. I
no
belong to a
question,
poor
no
family,
question.
my lord. I could not.
No. The court finds that despite an opportunity granted to the petitioner way back on 7th January 2013, that is 10 years ago, to recall witnesses subject to his depositing costs, that order was never complied with. Consequently, the impugned order dated 1/12/2022, passed by the trial court, rejecting a similar player, does not call for interference. The petition is dismissed.
item number 72,
None appears dismissed.
73,
May I please your lordship? Your lordship may grant some time to removal of defects.
No, what's the matter about?
Uh, Your Lordship, matter relates to direction to operate and unblock the salary account of the petitioner, that is Mahesh Jena. And the matter is listed for the first time, Your Lordship, after filing the
That's all right.
CRLMC.
What's the ground? Why can't you make this prayer to the trial? Why should you come here? The prayer made in the present petition could easily be made before the trial court in accordance with law. The permitting the petitioner to do so, the petition is disposed of.
Item 74.
May I please? An application challenging the quashing of the order dated 21/1/2023. My lord, Belgium matter. The petitioner could not attend only single date, 21. That's why the NBW issue against the present petitioner.
What's the offense?
383, 386, 307, 506.
Not inclined, sir. You put the prayer, the petitioner is not, the court having heard learned counsel petitioner, the court is not inclined to grant the relief as prayed for, the petition is dismissed.
Item 75.
May I please, Lord? Item 75, my lord. My lord, two orders has been passed. One is in DV case, and that has complied by me, and maintenance has paid by me. And by suppressing the material fact before the London JMFC, she filed another maintenance petition before the under section 125 before the family judge, London family judge Baleshwar.
What is the amount granted?
My lord, the initial first amount has been granted 3,000 rupees per month, and prior to that, my lord, your lordship kindly have a glance page 38 of my petition, my lord.
No,
I have
6,000 from the date of the petition, that's all.
3,000.
No, no. Page 62.
Page 6. Page 60, page 62. My lord.
What's
That
the
is
amount?
6,000 per month.
That's what I'm telling you.
My lord, what happened in this case, my lord? My lord, in this case, the on 24/2/2019, marriage was solemnized, and 29/10/2019, opposite party fled from my house. Repeatedly, I went to her house repeatedly. On 19/12/2021, she filed I filed a CP case 482 of 2021 before under section 9 of Marriage Act, my lord, Hindu Marriage Act. So that is also pending, my lord.
All right.
My lord, I have already cooperated with cooperated with the opposite party, and categorically I have stated before that repeatedly, my lord, on the that on 15/1/2020, 17/2/2020, 10/10/2020, 4/7/2021, 28/8/2021, and 19/12/2021, and requested her to come back, but she never turned back. The petitioner is constant to file a case under section 481 of 2021 before the London family judge Baleshwar under section 9 of Hindu Marriage Act, my lord. And that is also pending, my lord. In the meantime, the opposite party filed a DV case before the London JMFC, and the order has been passed by the London JMFC, and that was also complied by me. And very cunningly, by suppressing all material fact, she filed a case before the London.
What do you do?
My lord?
What are you doing? What is your avocation?
Well, I am doing in private job, my lord.
How much are you earning?
Earning minimum.
No idea.
No, I have not taken
Very good.
instruction.
Maintenance case, you have no idea how much your client is earning. Very good. How are you arguing these cases?
My lord, my sole point before
some client has given you saying, go and argue, sir.
No,
you
no,
got and argue.
I am on the point, my lord.
What is the point?
My lord, on DV case, once maintenance has already been allowed. And prior to that, my lord, before order passed, I have also deposited some money in my wife's account through bank account, and that has also been annexed. In the meantime, very cunningly, he filed.
The only word you have hang on to is cunningly.
My lord,
6 times you have told me cunningly. But what does your client do? How much does he earn? Nothing. That information is not there.
My lord,
your client has told you my wife is very cunning. So you said, okay, let me immediately file a petition.
My lord, what happened in this case? That 2 orders has been passed. One order is 3,000, and prior to passing that order, I have deposited as and when required. I have deposited some money. Your lordship kindly have a glance. Page 35. That is the receipt. Jetteବେଳେ she wants, I deposited some money prior to that. And I filed a case under section 9 before the family court. And that is also pending. But thing is that, my lord, I am ready and willing to take my wife. But she did not come back to.
Correct. All right. The intermittence amount awarded by the impugned order of the family judge is only rupees 6,000 per month. Yeah. Under section 125 of the CRPC. So stop. The amount awarded as entry maintenance under the in the DV miss case 8 of 2022 is only rupees 3,000 per month. Paragraph. It is not the case of the petitioner that his financial position is such that he is unable to meet the above, comply with the above orders. Consequently, at this stage, the court is not inclined to interfere. The petition is dismissed.
My lord, I am ready and willing to take.
Very good, sir. Very good.
Item 76.
That may be all.
Not necessary, sir. Right. For maintenance, that's not necessary. Right. Yes.
May I please? Here, my lord, the dispute among the lecturer and principal of a school, college. My lord, here the petition number 1 is the principal of the college, whereas the petition number 2 and 3 are the lecturer. And the opposite party number 2 is also one of the lecturer, and his allegation that he was appointed as an invigilator to conduct the +3 honors examination. Along with him, 2 to 3 other lecturers were also invigilator, but they did not cooperate to him. For that, he faced the trouble and accordingly informed the same to the petitioner. Petitioner number 1, that is the principal. And the principal called the informant, so also the other 2 invigilator who at least did not cooperate in the examination. They are, my lord, that exchange of hot words. Case and counter case. May I pray, my lord, one thing? My lord, since there is a dispute among the notice may be issued to the, so it can be settled among themselves, my lord.
Not all.
The charge sheet has been filed and
charge sheet is
permitting the petitioner to raise all pleas at the appropriate stage. Let's put the prayer clause and service. All right.
To raise all the points.
Yeah. Item 77.
May I please, madam? I am adjourned to 2 weeks after to remove the defect, madam.
No, tell me what the matter is.
Matter is that crossing of FIR arising out of 1cc case. The OP number 2 is the mother-in-law, and all the petitioner elder son, the grandson, and daughter-in-law. And the final report, my lord, the allegation which was given in the FIR in the final charge sheet is all has completely false, my lord.
You can raise all pleas, sir.
30 pages.
Raising all the pleas at the permitting the petitioner to raise all pleas at the appropriate stage. The petition.
You notice please.
It's all right.
Yeah. 78.
Pleasure, Lordship. Lordship, the petitioner challenged the cognizance order dated 17 January 2023, which is annexure 2, page 16 to 17,
Yes.
and the entire proceeding against the petitioner. Issue notice to the opposite party, my lord.
No, 307, madam.
My lord, the petitioner is an advocate, and the case is that annexure. Kindly, Lordship, kindly see the annexure. Annexure 1. That the FR is that I am the case conducting advocate of the accused Vasanta Pradhana. As he said that the advocate that's told that the advocate proceeding to court the road, but in that time the advocate is present at the honorable court. He is not present at the place of occurrence, and also for social stigma, the petitioner is filing anticipated bail to this honorable court, and which is the annexure. Let's see, annexure 4. And the ID card of the petitioner is annexure 3, my lord.
You got anticipatory bail.
My lord.
You should be very happy.
My lord, as the local police is searching for to arrest me, as I am the case conducting advocate and not involved in the case, my lord.
Have you become secretary of some bar association? Not yet.
My lord.
Have you become the secretary of that bar association? No.
My lord, the petitioner also. My lord, the petitioner also. When the local police arrest the.
All right.
My lord, when the police
not inclined, madam. What do you want to do?
Issue notice to the opposite.
No, I am not inclined to grant that prayer. What do you want to do?
My lord, cognizance order dated 17.
All right. Just put the prayer clause permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed. All right.
Item 79. Item 79.
Right.
No.
None appears dismissed.
Right. Item number 80.
Item 80 just you also kindly taken after research here.
No. Tell me what the matter is.
The file is not with the Passover, your Lord. Just
or it's Passover.
Yes.
It will come now another 5 minutes.
Item 81.
May I please, your lordship? Here, my lord, the petitioner challenges the inferior order under Annexure 3, my lord. Order of cognizance that is at page 47, my lord. The London Magistrate has taken cognizance of offence under section 294 of IPC, my lord. Facts is that, my lord, the minor daughter of the petitioner number 1 was kidnapped by the son of the opposite party number 2 in 2014, my lord. He was arrested. Thereafter, my lord.
What is the current status? Twice you took adjournment.
My lord.
You took adjournment twice to inform the court of the current status of the proceedings.
My lord, it is pending, my lord. It is pending. I have got the one certified copy, my lord. May I am handing over, my lord.
It's all right. Charge sheet is already filed, sir.
Yes, my lord. Charge sheet filed, my lord. So far as the offence under 294 is concerned, it is not at all made out. Even all the your lordship will examine all the 161 statements of the witnesses, my lord. None have implicated, my lord. Only to harass the petitioners, my lord, in view of the fact that the opposite party number 2's sons had kidnapped the minor daughter of the petitioner number 1 and 2. This false case has been foisted, on the basis of which cognizance has been taken, my lord. 294 is not at all made out, my lord. Even if the entire evidence is taken into consideration. So far, the evidence collected by the police, my lord. None of the witnesses have supported the case of the informant, my lord. My place, of course, it is in Orissa, my lord.
Where is supposed to witness supporting trial? Trial is happening.
Because police has filed charge sheet for the offence under
after charge sheet, nothing has happened.
After charge sheet, cognizance has been taken for the offence under section 294, even though it is not at all made out, my lord.
Right.
May I place, my lord, the evidence of the witnesses?
That's not evidence, sir. That's 161 statement.
Because, my lord.
161 statement, sir. That's not evidence. Yes.
In fact, my lord, it's not made out, my lord. 294.
It's all right.
It is not within the it should be within the public view, my lord.
All right.
It should be as per section 294. Yes. Ingredients of 294 is also not made out.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is dismissed. Yes.
Item 82.
82, may I please, the lordship? Lord, permitted to raise all the points.
Yes. Let's see.
Item 83.
The question of the city case number 694 of 2017. The SDM Devgad.
468, 467. So it's some forgery case. Land acquisition case, forgery, sir.
Yes, sir.
All right. Permitting the petitioner to raise all fields at the appropriate stage. The petition is disposed. All right.
Item number 84.
None appears disposed.
Both. Item 85. 85, may I please your lordship. My lord, this matter is covered by your lordship decision where the company is not a made a party.
Ah.
But yes.
All right.
None appears. None appears.
This- I've handed over. I've handed over the decision, my lord.
The prayer clause you put out, and then you say it is seen that the case is instituted against the present petitioners in their capacity as managers of Grasim Industries Limited. However, no, but you're an occupier, right?
Yes, one is occupier and another one is your lordship unit head.
I
That
don't
is
think this decision will apply that, sir, because the Factories Act goes on a very different process. Factories Act goes on a very different principle. Under the Factories Act, it's enough to go against the occupier. This principle will not apply there, sir. You have been described as the occupier and manager, right?
Yes.
So that principle of occupier in Factories Act stands on a very different footing. Let this be tested in the trial courts, permitting the
My lord, let the matter be passed over, my lord. Mr. Misra will do this matter.
All right. All
Yes.
right. Pass it.
Yes. 86. Madam, matter has been compromised. Opposite party already appear and file a affidavit. Well,
Counsel for opposite party number 2 confirms the affidavit filed by her, stating that the parties have already settled the disputes.
Okay.
And he does not wish to proceed the matter any further. Take the prayer clause. All proceedings consequent thereby hereby quashed.
Item number 87.
Matter has been compromised. Offense is 498A.
I am applying for the OP2, your lordships.
All right.
And I am residing with my husband, your lordships.
All right. Same order. Take the prayer
Okay.
clause. All right.
Item 88.
None appears dismissed.
89.
Same order.
Item number 90.
90, may I please, your lordship.
My lord, permitted to raise all the points.
All right. Permitted.
Item 91.
My lord, here I have challenged the rejection and application under section 205, my lord. The petitioner and the opposite party number 2, they are brothers, my lord. And the opposite party number 2 adopted to the.
We appear on a particular day. If we give you a date, you appear on that date.
My.
One day you have to appear.
Yes.
The petitioner will appear before the trial court on 3rd July.
My lord.
Till then, no course is just be taken against him. Thereafter, it is open to him to apply to the court for appropriate orders.
In that case, also, I am appearing for the opposite party of 2 lordship. He has appeared before the court below and taken bail lordship in view of the.
Anyway, he has to appear anyway after that also.
So, one more pair lordship, case of the year 2009 lordship.
It will be open to the parties. Yeah, it will be open to the parties to request the trial court to expedite the proceedings. All right.
But time period or lordship may fix. Once is a case or lordship, complaint case.
It's all right,
Since
sir. They also
2009
have a
lordship,
heavy board.
We are in.
You cooperate, it will all get done. All right.
Item 92. 92.
None appears dismissed.
93.
Same order.
My lord, my 92 and 93 both are same matter, my lord. I may be permitted to raise all the plot before.
All
the
right. All right.
93 and 94.
93, 94.
Right. Permitting to raise.
Item 95.
May it please, your lordship. I am appearing for the intervener in this matter, your lordship.
All right. Petitioner has submitted a memo seeking leave to withdraw the petition, dismiss as withdrawn.
My appearance may kindly be noted.
All right.
I am appearing for the intervener.
All right.
Item 96.
Grateful, your lordship.
My lord, item 96 arising out of a 457 proceeding, my lord. Vehicle stand recorded in the name of a partnership path. Two partners filed application before the London Trial Court to release the vehicle. My application filed by the present petitioner that was allowed by the trial court on the ground that the vehicle has been really seized from my occupation. Your lordship, that has been challenged by the present OP number 2 before the London Session Judge, and that has been allowed by the Annexer 10 at page 95. Though the vehicle stand recorded in the name of partnership firm, the present OP number 2 filed the revision and filed the application.
Where is Mr. Lalitendu Mishra?
My lord, on behalf of Mr. Mishra.
Where are you? Where is he?
My lord, his father's admitted in
All
ICU.
right.
Is gone
It
there.
is stated that Mr. Lalitendu Mishra, counsel appearing for opposite party number 2, is in some personal difficulty today. At his request list before the roster bench on 1st August. All right.
Item 97. 97.
Same.
98.
Then you said defect speak out in the meanwhile.
My lord, 96, 97 is also same. Two
That's what.
applications- Same, my lord.
Yeah.
Sorry, my lord. Yeah.
Item 98.
None of this dismissed.
Item number 99.
None of this, the petitioner put his appearance. Dismissal non-prosecution.
Item 100.
None of this dismissed.
Pastor matter item number 80.
May it please, Your Lordship. My lord, this is the third round litigation the petitioner is there before Your Lordship. Unfortunately, Your Lordship, I am accused in a case way back in 2001. Your Lordship may kindly see, two orders have been passed by this honorable court. As per Annexer 3, page 34. In 2017, Your Lordship has been pleased to direct that let it be disposed of expeditiously. Now, Your Lordship, when nothing could be done, then page 36, Your Lordship may kindly see, page Annexer 4, page 39. Now, herein there is a clear direction on 16/9/2021 to dispose of ER case number, vigilance PS case number 30 dated 36/2001, 22 years back. Now, my entire career I have spent, and till date, Your Lordship, out of 45, till date only 15 witnesses have been examined. It is not known even how long it will take.
Right. Notice vigilance is yours, sir.
My lord.
The vigilance department will place a detailed report before this court on the progress of the case and the present status list before the roster bench on 8th August. All right.
May I please to mention, my lord?
Item 85.
I am in the virtual mode, lordship.
May I pray that Your Lordship may kindly also direct the London lower court to expedite in the meantime.
That obviously, when they know that we have
If Your Lordship will direct, I'll produce that certified copy also.
All right.
May I please to mention, my lord, item number 41.
Your Lordship may.
In the meanwhile, the concerned court will expedite the matter. All right.
May I please to mention, my lord,
Yes.
item number 41.
41.
Yes, my lord.
In this case, in the meantime, the final report has been submitted by the IO, concerned IO.
So it's infructuous.
Yes, my lord.
Counsel, the petitioner states that on account of subsequent development, the present petition has been rendered infructuous. It is disposed of as such. All right.
Master item 85. 85, may I please?
We'll have it on some other day. You see,
on another date, my
7A,
duty of the
petitioner
occupier.
seeks time to examine
The occupier.
whether the position of a single court's occupier, unquote, under the Factories Act 1948 stands on a different footing than any other manager or director of a company. In whose case the company may not have been made an accused. Full stop. At his request list for the roster bench on 14th August. All right.
Obliging. Interim order was there, my lord.
Was there an interim order?
Yes, Your Lordship.
All right, interim order. All right.
Much obliged.
Because I will be misunderstood to you to non-appearance.
Not this bench, sir. This is a different bench.
In item number 1, my lord, the review petition, just now I have filed counter affidavit by the department and I have sought
No
copy
counter
of
is
my
necessary,
lord's.
my lords. No counter is necessary at all.
No, but
yes,
that is not
nothing is required.
No, it's all right. It's all right.
Yes.
All right.
My lords,
No, but he has filed a counter. Let it.
I have got the counter. I have nothing to say. He says, "This, my lords, your lordship, remember."
It's not common record, Mr. Right. It's not common record.
Just now I have filed through e-filing.
The second one.
Second one, both the
Second,
matters may
no, second one is not. It is tagged only with that. Second one is not for
Anyway,
review.
no more time for counter. So whatever he files now. All right.
My lords, lordship, it is a lordship's prerogative to file, give a date. But may I submit, my lords? I'll submit only 2 lines with your lordship's kind permission, if your lordship give me. The judgment was rendered on 1st of December 2022. This is uncontroverted. And your lordships said that, disposed of the writ petitions by saying that I raised all objections before the, in as much as to avail the alternate remedy. This is uncontroverted. And your lordship relied on a coordinate bench decision where Justice Raman was the author. And he relied on a decision of Anshul Jain, my lords, which refused, the Punjab Haryana High Court refused to entertain the writ petition challenging the order passed under Section 1, Clause D of 148A. Now, my lords, the Supreme Court has again stepped up. It's a now front gear, my lords. Red Chili International, my lords. I'll give that judgment of the Honorable Supreme Court. And in view of that judgment, my lords, the judgment as has been rendered on 1/12/2022 is now impliedly overruled. I'll give that judgment now. I'll read it also. Mate diyontu. The Punjab Haryana High Court, the same quorum which refused to entertain the writ petition on the ground of that you can urge all the grounds. I read the relevant paragraph. Page 2, my lords, the relevant para. I am not wasting your lordship's time because of the lunch hour. It's a very dangerous hour. The provisions of reopening under the IT Act 61 have undergone an amendment by the Finance Act 2021, and consequently the matter would require a deeper and in-depth consideration, keeping in view the earlier case law. Full stop. Accordingly, we set aside the observation made by the High Court.
Only the observation, sir.
This is
not the judgment of the High Court.
Judgment of the High Court. We set aside the observation. High Court, my lords, it is just like that, my lords. In the Anshul Jain case, the High Court, what the High Court held.
No, but the judgment is not overruled, sir. So the point is the judgment should be set aside categorically. What they're doing
set
is
aside
they're only saying
yes,
that observation of the High Court, which said in a 226 we will not entertain.
That has been set aside.
Observation is being set aside, saying
yes,
this issue would be examined in depth by the High Court
as and when it is required.
So that's
as and when it is required, my lords. My lords. Then no. This is I am submitting. Lordship is a great master in income tax, is so considered, my lords. Lordship knows better than me. Lordship knows that so far as the Anshul Jain's case is concerned, my lords, Lordship have seen that order. The Supreme Court, M.R. Sahan, that has given. That has also only ratified that order. And your Lordship is aware of the judgment of Justice Lahoti, decided in. So Justice Lahoti or dissent adiyontu. How to become, what is a precedent while the High Court order is being challenged.
Sir, all this, I think you should argue in the Supreme Court. All this.
My lords?
All this should be argued in the Supreme Court. What is the impact of that?
No, that is correct, my lords. I'll argue. Yeah. But now, my lords, the Ambika Iron and these two things, they are filing the counter. It is by I have said, this is not my main focus on the, they say they are now asking, what your Lordship will see, that in Ambika Iron, there has been two so-called notices. One was given in May. Ambika Iron filed that. One was given on review. Original date. Yes. Lordship sees so-called notice was issued 30th of May 2022, Annex 1 at page 12. Reply given at Annex 2. And I have accompanied the judgment of this sestat. Then, my lords, the order was passed on 30th of August 2022. Now, what has happened? They have issued another so-cause. Now they claim in the counter today I have received that this is to be deemed to be a so-cause. Where is that power given under the statute that your Lordship that they observe too much natural justice, if I remember properly?
No, but let's keep the review petition aside now.
Yes.
The review petition will simply say no ground made out for review. The review is dismissed. The writ petition will say list before the roster bench. There you argue fully, sir. The writ petition will say list before the roster bench on whichever date.
Review.
The review is over, sir.
Writ petition is
Tarini's auto space. So that will place before the roster bench. That before the roster bench.
Yes.
Roster bench on 2nd July.
2nd July, my lords,
interim order to continue.
Operating.
Interim order to continue.
Bad.
All right. 3rd July. 3rd July.
Malice.
Right.
Malice.